Time out. You're being very dishonest and slippery with me because I asked you, my mind is a steel trap, but I wanted the court reporter to read back because maybe my mind is failing, but I highly doubt that. You told me that your children were living with you and their father, and you said the other father, he's not a part of anything. Now you're telling me, oh no, he doesn't live with me. It's on and off. You've been dishonest with me from the very beginning. You were dishonest when I asked you if you're going to be positive. You were dishonest about that. Then you were dishonest about Bloodworth. I don't even know if this is this person's real name or not. Then you were dishonest about Sarabia. At first, and later you said he was the father of your children. Now he's not the father of your children. You're just being dishonest all across the board with the court, and I don't appreciate it. Counsel, it appears that the state is proceeding on the indictment as presented. Is that correct?
It's my understanding, Judge.
State, is that correct?
Yes, Your Honor.
Ms. Rubio, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did.
Did you understand you're charged with the offense of theft of a firearm? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, she does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Ms. Rubio, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. State is not making any recommendations on your application for deferred. Is she applying for deferred?
And Your Honor, for clarification, after the discussion with Ms. Rubio, we would respectfully request that we go forward on a regular community supervision. Your Honor, she does not wish to apply for deferred, and in the interest of justice, pending any type of evaluations that the court deems them fit, I would ask for sentencing today, Your Honor.
All right. So the state recommends community supervision. They're taking into consideration night mag number 716819, grand jury number 785613, JN number 2097716. There's to be restitution to Kyle Barney, KYLEBORNE. And you ought to agree that this crime was committed as a party with William Gordon and Nicholas Sarabia. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
All right, state and defense, if you'll initial where the defendant has decided to proceed for regular probation. Next, I'm going to show you what's entitled a waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there been any such motions?
There have not been, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There be a TAP evaluation and 200 hours community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence
State offers States Exhibit 1 and all of its attachments.
No objection, Judge.
showing you what's entitled waivering consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Off the record. Norma, we'll need the interpreter back. Back on the record. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
All right. And states you may be excused to continue to confer. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
In the interest of justice, that would be our request, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I stand here with Ms. Rubio. As the court is aware, we had a minor issue with respect to her bond. In order for judicial efficiency and to get on with her life and begin the process of putting this behind her, she sought my direction at attempting to resolve all matters. And that's what she wanted to do today, is to accept responsibility, come forward and start the process of putting this behind her with whatever conditions the court deems appropriate, given the totality of the circumstances and the information the court learned today.
All right. Are you employed?
No.
How do you support yourself?
Currently I am not. Since I went to jail for this, I lost my job, so I'm still looking for a new one.
So when's the last time you were employed?
The beginning of June, or the middle of June, I guess. Maybe about the middle of June.
Do you have any children?
Yes, 2.
What are their ages?
She just turned 12 and 14.
Who do they live with?
They reside with both me and their dad.
Who is the father?
William Bloodworth is one of them.
I'm sorry, who?
William Bloodworth. He is the father of my daughter.
Mhm.
And my son's father is not involved. He takes that place of that.
So you're saying you're living with William Bloodworth? Yeah, but in this, it says that Nick Sarabia is your boyfriend. That's what it says in the police report.
Okay.
No, I mean, it's not okay. That's what it says in the police report.
And
So
he
who is
was-
this other person?
That is my kid's, sorry, that is my kid's father.
No, you didn't mention Nick Sarabia as being the father of
No,
any.
he's not the father of my kids.
No, excuse me.
I'm sorry.
Can you tell me what she just said in regards to Nick Sarabia?
I didn't say anything on this.
Pastor, do you have any children? Yes, 2. What are their ages? She's 12 and 14. You asked who do they live with? Her response is they reside both with me and their dad. Who is their father? William Bloodworth. William Bloodworth is his father, is the father of my daughter, and my son's father is not involved. He takes that place. You want me to keep reading?
Yes, please.
Yeah, but in this, it says that Nick Sarabia is your boyfriend. That's what it says in the police report. She said, okay, no, it's not okay. That is what it says that's what it says in the police report. And she says, that is my kid's, sorry, my kid's father, no, and then I have cross thoughts.
Oh.
You didn't mention that Nick Sarabia is being their father.
All right, thank you. So you said that Nick Sarabia was the children's father, but you just told me that,
I'm sorry, he is not the children's father. He was the boyfriend at the time. He is locked up right now. We have not spoken.
Mhm. And then why were you dishonest with me about your drug test?
I'm sorry. That was 7 days ago. I didn't think that it was me.
No. That should not be in your system from 7 days ago. When's the last time you used and what are you using on a regular basis?
7 days ago.
What are you using?
There was meth on 7 days ago.
No, listen to my question. What drugs are you using?
Meth.
How often are you using meth?
Last time we did it was 7 days ago. 7 days.
And what else are you using?
Nothing else.
And what is the father, Mr. Bloodworth, what is he using?
Nothing. Oh, your brother? Nothing.
I find that people,
We don't live together. We both share custody of my kids. They live with me and then they live with their dad.
okay,
We
she's,
do a joint custody.
time out. You're being very dishonest and slippery with me because I asked you, my mind is a steel trap, but I wanted the court reporter to read back because maybe my mind is failing, but I highly doubt that. You told me that your children were living with you and their father, and you said the other father he's not a part of anything. Now you're telling me, oh no, he doesn't live with me. It's on and off. You've been dishonest with me from the very beginning. You were dishonest when I asked you if you're going to be positive. You were dishonest about that. Then you were dishonest about Bloodworth. I don't even know if this is this person's real name or not. Then you were dishonest about Sarabia. At first, and later you said he was the father of your children. Now he's not the father of your children. You're just being dishonest all across the board with the court, and I don't appreciate it. And dishonesty has nothing to do with nerves. You heard my questions. My questions were very specific.
Yes.
All right, this is what the court is going to do. I'm going to find you guilty. I'm going to recall the warrant. I'm going to sentence you to 2 years in the state jail facility, suspended and probated for 4 years. There's to be no unsupervised contact with minors. Is CPS involved in your life?
No.
Well, I mean, why are you saying no? Like they should be. You're using meth and you're taking care of children. CPS should be involved in your life. So I'm going to want CPS compliance. If CPS is involved in her life, I don't know if they are or not. She's been dishonest with the court. I'm going to want the UA hotline until further notice. Intensive parenting classes. I'm going to want field visits, random, 1 time per month until further notice. Please check on the children. There's to be no contact with the person who she's saying may or may not be the child's father. There's to be no contact with Nicholas, Anthony, Sarabia. And that means if he's at the Bexar County Jail and he calls you and you know it's coming from the jail because they're going to ask you if you'll accept the collect call, you need to hang up because otherwise I'm going to count that as contact. And it's easy to see if that's happening because they keep a record of every phone call from the jail. Do you understand? There's to be no contact with William Clark Gordon. There's to be regular reporting by Zoom or in person. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Taking consideration NIMAC number 716819. And Brittany, if you could do the rejection for me on that case. All right. All right. It's NIMAC number 716819. grand jury number 785613, JN number 2097716. 200 hours of community service restitution. Those will not be waived. TAP evaluation. And once the TAP evaluation is complete, she's going to start with intensive outpatient treatment. And the court is noting for the record that she's agreed she was acting as a party. With William Gordon and Nicholas Sarabia. Probation, is there anything else she needs?
No, Your Honor.
Oh, and I'm sorry, there's to be restitution, if any, to Kyle Burney, Kyle Eborne. Is there anything else you need from the court to be successful? I'm sorry?
I don't think so. I think everything sounds like it's gonna help.
Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Your children are depending on you to raise them, and they cannot be raised by you if you are using drugs. And the people that you bring into your children's life should be people who are not using drugs. Do you understand? All right, good luck to you. All right, can I see the interpreter, please? And then Norma, after that, we'll take up the other matter. And it is on Jose Soto Victorino. All right, thank you.
It's not present yet.
Oh, okay,
Maybe there's the state. I'm
okay.
dealing with Daniel on it,
All
so.
right, just give us a moment then.
Okay.
Thank you so much. They're bringing him up.
Yeah.
Where's Anthony Cantrell's client? And where's Anthony Cantrell? Okay. All right, who's here on Jennifer Cano?
I'm here, Your Honor.
Where's Jennifer Cano?
Hi, Judge, she's on her way. We had lost communication with her. We informed her of this court date. She communicated with my office this morning that she's here. Could we get this recalled for another day?
No. All right, we're going to go on the record. Court is calling 2023 CR 6019, State of Texas versus Jennifer Cano. Can I see someone for the state? Should I have parties announced for the record for the state?
For the state.
Defense?
Shannon Locke for Jennifer Cano.
All right, this hearing was scheduled at 11:15 a.m. It is now 9 a.m. Your client has not appeared in court. Deputy Laura, did you make an announcement?
Yes, sir. There was no answer.
Counsel, where's your client?
I'm not sure, Your Honor. So she's communicated with my office that she would be on her way. And so we would ask that this be recalled for another time.
State?
Your Honor, the state would be requesting a bond forfeiture.
All right, that'll be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Your Honor.
You're welcome. Oh. Yeah. Just leave it on. All right, who's here on David Martin? David Allen Martin. Okay. Patrick Sanchez.
The state said they were going down to, and he's in custody as well.
All right, Mr. Sanchez, come down. All right, what is happening with this case?
So I've confirmed briefly with the state. This is my first setting on this individual. And so I was recently assigned to it. It looks like he was, I believe, just released from the state hospital about a month and a half, or recently, I think he was in the state hospital for about a month and a half, waiting about 18 months to get there.
Okay.
I've conferred with state, requested more discovery. My review appears that there's still quite a bit missing.
All right, Ms. Ferguson. On this case, recall it in 2 weeks for discovery and we'll see where we are.
Thank you, Judge.
What date?
Give me 1 second. I can do the 24th.
All right, we're going to come back on August 24th.
Yes, Judge.
All right, we'll see you then.
Thank you, Judge.
Yes. Who's here on Tyler Small? All right, where's your client?
He's in custody in Comal County right now.
Okay. All right, Norma, this is for sentencing.
It's not a new number one, just for the record, Judge.
So he's in Comal County, so we need to have him by Zoom in Comal County if they do that. So what we'll do is we'll reset it.
This month.
And Norma, on this, although I know it's going to take longer, can you just reset it for 2 weeks and see where we are?
24th.
All right, so we'll come back on August 24th and hopefully we'll be able to have him by Zoom.
And if anything changes, Judge, as far as him getting released, because it was supposed to be a time served thing,
Mhm.
I'll get with Norma and set it sooner.
Okay, all right, thank you.
Thank you, Judge.
Sorry, Judge, I'm here now.
All right, who's your client?
David Allen Martin.
All right, David Allen Martin. Oh, just give me a second. Okay. Court is calling 2023 CR 4087, State of Texas versus David Allen Martin. Could I have the parties announced for the record for the state,
Stacey Harrington.
for the defense?
Anthony Cantrell.
Are you David Allen Martin?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Barton, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge. No, I'm sorry, Judge. This is 4087.
Yes.
State is proceeding solely on count 1, waiving and abandoning all remaining counts. And do you have both cost numbers?
Yes.
Or are we just doing one at a time?
No, I'm going to go to that first one, that one next. I just want to make sure we have this one.
No problem, Judge.
So you're waiving counts 2 through 13?
That's correct, Judge.
Any objection?
No objections.
And then the next case is 2023 CR 4088, State of Texas versus David Allen Martin. Counsel, have you received all the discovery in that case?
I have, Your Honor.
Court will find that the state is in compliance with discovery in that cause number. Mr. Martin, in that case, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge. State is proceeding solely on count 1 and waiving and abandoning the remaining counts.
No objections.
Okay. So count 2 through 5 are waived without objection. Mr. Martin, in each of the cause numbers, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand it? And did you sign them in all the appropriate places?
Yes, ma'am.
And the cause number ending in 4087, you're charged with the offense of promotion of child pornography as a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. And the cause number ending in 4088, you're charged with sexual assault of a child. The range of punishment for that offense is anywhere from 2 to 20 years in prison and a possible fine of $10,000. Did you understand? And each cause number, if you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering into these plea bargain agreements, you were giving up those rights?
I do.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Martin, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
All right, you're going to have to keep your voice up so I can hear.
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, I'm showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
In each cause number, the state is requesting that your punishment be assessed at 10 years in the prison. There's a $2,000 fine. There are no applications. The cause numbers will run concurrently. State will take in consideration 2023 CR 4144. 2023 CR 4143, and there's to be Chapter 62 compliance in each cause number. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
In each cause number, I'm showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, there's to be no contact with the complainant. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then in count one, ending in the cause number 4088, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And cause number ending in 4087 to count one, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's pleas of guilty.
State offers State's Exhibit 1 and all attachments in each cause number.
No objections.
In each cause number, I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them and did you sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same.
And just to note for the judge, stipulations are the same in each cause number.
All right, thank you so much. All right, And each cause number at the review and states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. And each cause number, the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
State, have you spoken with the complainant?
Yes, Judge.
And is she aware of this?
She is, Judge. She's actually currently in juvenile detention.
Okay.
She received a tampering with evidence case, and we're actually trying to get her treatment at this time, Judge. So she is aware.
All right. Is there anything you'd like to say on behalf of your client?
No, Your Honor, we just asked the court to follow the plea bargain.
All right. What would you like to say?
I don't have anything to say.
I'm sorry, I cannot hear you. You need to speak up.
I'm sorry for my actions, man.
Oh, are you sorry for your actions, or is it because your attorney told you to say you're sorry?
I'm sorry for my actions. It's just a lot.
Are you married?
A lot of resort. I plan on getting married.
Who are you getting married to? Does she know about this case?
Yeah.
I'm sorry?
She's in the courtroom.
Ah, so she knows that you
She knows.
were having sex with an underage child.
Honest with her about it.
I'm sorry,
I
what?
was honest about it with everything.
And she still wants to be with you. Do you have any children?
I do not.
All right. And I see that the child was 16. Well, I mean, not you believe so. In the police report, it says that she told you she was 16.
She didn't tell me anything.
I think he found out after the fact.
He found out while they were together, Judge. Yes.
Okay. So you knew. And the person you're with who's here to be with you and support you, does she have children?
No, ma'am.
And how old is she?
She's 34.
And
She
who
knew the
is it?
complainant as well, Judge. She was there during this whole time.
What is her name?
She's in the police report. Lauren Messwich.
Let me find her in the police report. And you say it's Lauren, Lauren?
That's correct, Judge.
And how do you spell the last name?
I might chop it up. Messwich, Mesch, I believe, WICH. She's in one of the reports.
All right, let me see if I can find her. Do you know how to spell her last name?
It's MESH.
Would you like me to locate it for you, Judge?
Yes, please. Thank you. All right, it's Lauren Elizabeth, and the last name is Meschwitz. All right, and so she's the person who wanted to have a threesome with the underage person, correct? I'm sorry?
It was both of us.
All right. And cause number 4088, the court is going to find you guilty. The court will sentence you to 10 years in the prison. There's a $2,000 fine. Time and money will not run concurrent. This will run concurrent with 2023 CR 4087. Take in consideration 2023 CR 4144. 2023 CR 4143. There's Chapter 62 compliance. No contact with the following: the complainant and Lauren Elizabeth Meschwitz, and give you credit for any time served. So your relationship with her is over. Do you understand?
Yes, ma'am.
Ms. Meschwitz, if you're not on the docket, you can leave the courtroom because your relationship with Mr. Martin is over. And cause number 4087, the court is going to sentence you to 10 years in the prison, give you credit for any time served. There's a $2,000 fine. Time and money will not run concurrent. This will run concurrent with 2023 CR 4088. Take in consideration 2023 CR 4144, 2023 CR 4143, Chapter 62 registration. There's to be no contact with the complainant and no contact with Lauren Elizabeth Meswich. Is there anything else from either side with regards to sentencing?
No, Your Honor.
No, Your Honor.
All right. And each cause number, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review those documents with your attorney? Did you understand them and did you sign them? All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing, whether you're telling me you knew she was only 16 or not, at the end of the day, you knew that the person that you were using was going through some drama in their life, and you were seeking to build your happiness off that person's misery. You cannot do that in this world. Do you understand? All right, at least good human beings do not. Good luck to you. Mr. Cantrell,
Yes, Your Honor.
here are the dismissals for you. You're welcome. Okay, thank you. If the yellows, yeah. Thank you. Have a good one, Mr. Cantrell. All right, are we ready with the interpreter, Jose Soto?
At large.
All right. Thank you. Always good seeing you. Have a great one.
Thank you, Judge. You too.
I'm doing my best. If you just pass it along to them that, yes, it was hot in this courtroom today. All right. On this case, all of the other co-defendants are being brought back on August 24th for the plea deadline date.
Okay, Your Honor, I've been conferring extensively with Daniel Escobar. I understand he's in trial right now. If we have a resolution before then, we'll definitely let Norm and Ms. Ferguson know.
Okay.
The 24th.
All right. So we will see you all back on August 24th.
Thank you, Your Honor.
All right. Is there anything else?
Nothing further.
All right. See you then.
Thank you, Your Honor.
All right. Thank you. All right. Who's here on Carlos Romero? All right. We'll wait for Mr. Cox to come back. Moses Ross.
Yes, Your Honor.
All right, Mr. Ross. And this was scheduled for PTD. Where are we on that?
Yes, Your Honor. After discussing with the supervisor, the case would not be eligible for PPD. So the state did tender an offer to counsel, and we've also submitted a discovery acknowledgement.
All right, your plea deadline date, Norma, can we call this back on the 24th as well? All right, your plea deadline date is going to be on August 24th. At that time, you need to let the court know whether or not you're accepting the state's offer. After that point, the court will not consider any plea bargain agreements without good cause. Do you understand?
August 24th?
Yes, they're going to give you a reset form.
So I come back here August 24th, right? And that'll be the last day that I could take in your deal?
Yes. All right, do you have any questions about anything?
If I come back, or when I come back August 24th, and I happen not to take the deal and I would hire a lawyer.
No, then you're going to jury trial. And let me just tell you, whoever you bring in, if you bring in an attorney on August 24th, you need to let them know that you're going to jury trial then. There's not going to be a continuance for them to get up to speed because this case has been on the court's docket since June. And in this court, we don't let cases hang around for a long time. You understand? All right. Is there anything else?
Oh, yeah.
And why were you late?
Just didn't wake up. I'm sorry. I apologize.
Here's the thing. Not, thank you for your apology, but if you're late, what ends up happening is a warrant may be issued for your arrest. I'm going to notate in the file that you were late because you overslept. Do not oversleep again. Do you understand?
Yes, ma'am.
All right. Thank you.
Thank you.
Who's here? Michelle Solis.
Your Honor, compliance hearing.
All right, Mr. Solis, if you'll come forward.
Morning, Your Honor.
Good morning. How are you doing?
I'm doing well.
All right. So the reason why we're here is the last thing that I have is reentry center in Houston, Texas, documentation not provided. Has that been provided?
Your Honor, let me double check.
What is that? The verification of the halfway house?
Yes.
Yes, ma'am. Yes, ma'am.
There is for residents, Your Honor.
Okay. And then
The proof of residence is the reentry home in Houston, Texas.
all right. So what does he have remaining to
Your
pay?
Honor, he was in custody when he signed for probation.
Mhm.
So he was just released on his parole violation
Mhm.
in June.
All right. So my understanding is that you're telling them you don't want to be extended. You will be extended. Do you understand?
Yes, ma'am.
I understand that you were placed on probation while you're in custody, but that means that you haven't done anything really because you've been in custody. So you're going to be extended. Now, if you complete everything early, then the court will consider removing you from probation or allowing you to terminate early. Do you understand? But you're going to have to show the court something.
Okay, ma'am. But when I got arrested, I got these charges, right? And they violated me and sent me to prison. So that time doesn't count.
No.
How come if I was already in custody for these charges?
Oh, because you're on probation for this case. Now, if you were not on probation for this case, and if you would like to be revoked and just do your time on it and have an attorney talk to the state and see what time they will be perhaps willing to give you, then of course the court will always consider that, but the court is going to extend you. And how much time do you want to extend him for?
Your Honor, I would need a little bit of time to look into that.
All right.
Currently, his probation expires on the 31st of this month.
All right. So this is what I'm going to do. I'm going to extend him. And I'm going to extend him for a year. If you get everything done and come back within 6 months, the court will consider terminating you early. But that means you cannot miss any appointments or anything. You understand?
Yes, ma'am. I'm still on parole also, and I get off of parole on October 12th.
All right. So I'm going to extend you for a year. If everything is good with you and you want to come back and can be considered for early termination, maybe if you want to come back when you're released from parole, then the court will consider it. You understand?
Okay. But
So-
until then, so I still have to pay the fines and everything.
Well, today, what we're going to do is I'm going to do the extension and I will do a minimum supervisory fee for him. And we'll go from there.
Okay. What is
So
that?
when you are released from your parole,
Yes, ma'am.
come back to the court. Just let probation officer know you want to come back to court to see if I'll consider early termination. But in order for me to even consider that, You cannot have made any mistakes or any missteps or missed any appointments. And you need to have completed everything that I'm requiring of you. Do you understand?
Yes, ma'am.
All right, probation. Is there anything else?
No, Your Honor.
All right, so you're going to sign for the extension today. And then, as I said, my mind is a steel trap, so I remember what I'm telling you. Complete everything, make sure there are no hiccups or missteps or any violations of any kind. And then you can contact probation and we can come back and I'll reconsider.
When I get off in October.
Yes, I'll reconsider at that time.
Your Honor, can we list him as virtual since he does live in Harris County? Or
Oh,
do you
yes.
want
Let me write that in the
entire
file.
term, transferred, or can we just do virtual?
We can do virtual.
Yeah, that's what I've been doing with my current probation officer.
Okay, I'll allow for virtual reporting and also virtual when he comes back. All right, is there anything else?
No.
All right, anything else you need from the court?
That's it, ma'am.
All right, thanks for addressing appropriately for court. I appreciate that.
Yes, ma'am.
All right. All right, are the parties here on Katrina Mendoza? All right, court is calling 2022 CR 4248B, State of Texas versus Katrina Mendoza. Can I have parties announced for the record for the state?
Brittany Mitchell and Marissa Giovenco for the state.
Defense?
Good morning, Your Honor. I'm Todd McCray for Katrina Rose Mendoza.
And are you Miss Mendoza?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Ms. Mendoza, I'm showing you what's entitled application for deferred adjudication. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are proceeding under count 1, paragraph B, and waiving the remaining counts, Your Honor.
All right. Any objection to the waiver of count 1? Excuse me. Any objection to the waiver of count 1, paragraph A, count 3, count 2, count 4, and count 5?
No, Your Honor, that's per our agreement.
Ms. Mendoza, I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand in count 1B, you're charged with the offense of assault intentionally, knowingly, serious bodily injury to a child? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to life in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to count 1 paragraph.
Other than in discovery, we ask for discovery of the phone and the contents of the phone. And the state's response was that the contents of the phone, that's the co-defendant's phone, is still being extracted because there's you might remember the hearing. there's a code there that they haven't been able to break.
All right, and I believe that's, if I'm remembering correctly, I believe that's the case where the defendant offered to,
Right.
Give
Well,
us code.
I'm being told we just got a cell phone. A cell
believe
phone
we just got the
download
second
in,
cell phone
so we can provide that to defense
Okay.
counsel.
Very,
All right.
very good.
so,
May have already been uploaded, to be honest. I've already given it to them to be uploaded, so I will double check on that.
all right, Ms. Mendoza, you understand that there's a cell phone dump from the co-defendant's phone?
Yes, ma'am.
And were you aware of this before entering this plea? That there was a cell phone?
Yes.
And were you aware before entering this plea that the state did not have the contents of that cell phone to turn over to your defense counsel?
Yes.
All right. The state has informed the court that that has been completed. Do you still wish to continue with this plea?
Yes.
And are you waiving your right to have the contents of that phone viewed before entering this plea?
Yes.
Defense, is that correct?
I concur.
All right. But even with that being said, state, you're going to provide that information to them?
Yes, absolutely, Judge.
All right, then to count one, paragraph B, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Your Honor, we offer State's Exhibit number 1 and all attachments.
Which I've reviewed thoroughly with Ms. Mendoza and we find no objections.
All right, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate
I
places?
did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily after reviewing states exhibits 1 and attachments, the court is going to find there's sufficient evidence to find you guilty. Court will defer finding you guilty as you've applied for deferred adjudication. Ms. Ferguson, when is the co-defendant set for trial? October 3rd? All right, so the co-defendant's case is going to trial on October 3rd. And we will send this for a PSI. And we will be back. You will most definitely be back on, I want to say October 4th, because we'll have jury trial on October 3rd.
Yes.
So, Ms. Ferguson, let's just put this on the docket for, let me look at the calendar. You know, the computer did an update and the update is just changed everything around on the computer. All right. So October 3rd, we'll probably do jury selection. So Norma, let's just bring this back on October 2nd to make sure that everything is still proceeding the way it's supposed to proceed. So we'll put October 2nd. And that's not the date you will have your sentencing. According to your plea bargain agreement with the state, your sentencing will take place after the co-defendant's jury trial. Do you understand?
Yes, ma'am.
So we're going to bring you back. We can go off the record. We're going to bring you back on October 2nd. Probation on Mendoza, I'll need a PSI done. We're going to bring her back on October 2nd, but the actual sentencing is not going to take place until after the co-defendant's jury trial. All right, so we'll bring you back on October 2nd to see where we are with the jury trial, but the jury trial should be proceeding on October 3rd.
And one final thing, Your Honor, if I
Yes.
may. So you could see that Ms. Mendoza's status right now, because she's dressed in red,
Mhm.
is pretty much what they call isolation. So
Yes.
she's isolated. She only gets 1 hour to be outside of that isolation. We would ask the court respectfully if the court would review her status.
Mhm.
If she is classified as protective custody status, She gets a few more hours out of the isolation. And I know the court knows this, but she also could participate in classes and things like that. So our plea would be to ask the court to review her status at the jail. And we would respectfully ask the court to classify her as protective custody rather than the isolation she's in.
All right. Well, what I can tell you is we've had situations of this nature before. It would be best so that I won't have any responsibility if something were to go awry. I'm not saying it would, but if you will reach out to the sheriff or to classifications and let them know you would appreciate her being reclassified, they will usually do that. But they're going to want it in the form of a letter from you signed by your client.
Okay, so you think a letter to the sheriff's classification requesting protective custody might do it?
Yes. And then if that doesn't happen, we can always come back and have a hearing on it.
You understand, Ms. Mendoza?
Yes,
Thank you. Your
All
Honor.
right. You're welcome. Is there anything else?
Nothing further from the state, Your Honor.
All right. Thank you.
Judge, I'll be 100% honest, I don't know.
All right. If you could look up to see if she has anything pending other than the theft case, then we'll take it up. All right. So once they look it up, they'll be able to tell me every case. So just give us a moment.
Thanks, Judge.
You're welcome. It's always great seeing you.
Appreciate that, Your Honor.
Although I'm used to seeing you on Zoom with your Oscar or your Emmy behind you.
Judge, that's a very good memory.
Yeah. So how was your weekend?
It was good, Your Honor. Thank you. Thank you for asking. Hope the same is true with you and everyone else in the courtroom.
Oh, no, the weekend was great. I didn't do what Bashan did, which was go see Meg too. Like, that's on you. She should have saw that one. That's all on you.
Judge, there are two cases, one burglary of a building, and the other one is possession, PD 1, 4 to 200. Both are awaiting indictment.
Okay. And possession, and that's 4 to 200?
Yes.
All right. So the other thing the court has is there's an affidavit to surrender surety on the case that's indicted. Counsel, were you made aware of that?
Yes, Judge.
All right. So that was granted on July 19th. So she has a warrant out for this case.
That's my understanding, Your Honor.
Right. And then there's also a motion to reinstate bond on this case.
I was made aware of that this morning. Ms. Rubio informed me that discussions with the surety company resulted in the surety wishing to approach the court to reinstate the bond.
All right. These other cases, the burglar of the building and possession, what are the offense dates on those?
Here, let me check that. I know that they were better.
Okay.
Yes, that would have been back in June.
Okay. And then the theft case, let me see what's on the indictment. That's June 3rd. And so you're saying these cases?
So Judge, the theft case, this happened back in June of 22.
Mhm.
The new cases happened in June of this year.
All right. I state if you have no objection to me reinstating her bond, I will reinstate her bond, but I'm going to add other conditions.
No objection to the state judge.
All right, we're going to go on the record. Court is calling 2023 CR 4281A, State of Texas versus Vanessa Faye Rubio. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Your Honor, good morning. Frankie Sandoval on behalf of Ms. Rubio.
And are you Miss Rubio?
Yes.
On this case, there was an affidavit to surrender surety, and the court granted that on July 19th, it looks like. And now the bondsman has just filed a motion to reinstate the bond. Any objections from the state to reinstate the bond?
No, Judge.
Ms. Rubio, I have to ask you some questions if I'm going to reinstate this bond. The questions I ask you will not be about the underlying facts of the case, but I do need to ask you other questions. So could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. I'm going to need you to speak up so the court reporter can hear. State your name for the record.
Vanessa Rubio.
All right. Ms. Rubio,
Ma'am.
have you had any mental health treatment before? Any diagnoses of mental health? Drug use? Oh, if I drug test you right now, what are the results going to be?
Negative.
Okay. All right, we'll do a drug test and then we'll come back. And the reason why I'm doing that, because the law has changed. If I'm going to be setting bonds, I need to make sure that there are conditions in place so that you won't reoffend. For example, if you have a drug issue and I know about it and I don't do anything about it, that comes back on me for not addressing that issue. So counsel, we'll do a UA today. And if there are no issues.
What began as a routine sentencing hearing quickly turned into a courtroom confrontation about honesty, responsibility, and drug use. Vanessa Rubio appeared before the judge ready to resolve her case and move forward with probation. At first, everything seemed straightforward. She accepted responsibility, agreed to the plea arrangement, and hoped to put the case behind her. But then the judge started asking questions. The judge wanted to know about Vanessa's family, her children, and the people in her life. That's when the answer started changing. First, she gave one explanation about the father of her children. Then she gave another. When the judge compared her statements to information in the police reports, the inconsistencies became impossible to ignore. The courtroom grew tense. The judge pointed out that Vanessa had already tested positive for methamphetamine earlier in the day. When asked about her drug use, she admitted that she had used meth only a week before appearing in court. That admission immediately raised concerns, especially because she was responsible for caring for children. Then came the moment that changed everything. The judge told Vanessa she had been dishonest from the very beginning. According to the judge, the problem wasn't nervousness. The questions had been clear, and the answers kept changing. One moment a person was the father of her children, the next moment he wasn't. One explanation contradicted the next. The judge made it clear that honesty matters in court, and once credibility is lost, every answer becomes harder to believe. Despite her frustration, the judge still gave Vanessa an opportunity to stay out of jail. Instead of sending her directly to serve her sentence, the court placed her on probation with strict conditions. Those conditions included intensive drug treatment, parenting classes, random checks, regular reporting, community service, and restrictions on who she could contact. But the strongest message came at the end. The judge expressed concern for the children involved and emphasized that methamphetamine use